we will discuss on how and when to protect your idea, how to establish your brand identity, how IP can help you to attract investor and partners, and some ways to monetize your IP. With this, I want to welcome our guest speaker for the session, Mr. Ravi Pandey. Ravi sir. So Ravi sir is currently working as the Research Establishment Officer, IP and Technology Transfer at IIT Kanpur. He is a qualified registered technology transfer professional with an experience of 11 plus years in IPR management, tech transfer, including policy development, startup incubation. He has formulated the policy framework at IIT Kanpur. He has worked as advisor on IPR issues for Jharkhand government and been awarded Outstanding Performance Award by Startup India for promotion of innovation related activities. He is currently managing an IPR portfolio of 950 plus IPRs at IIT Kanpur and has facilitated 60 plus tech transfer transaction in his career. He has been a keynote speaker at several IPR related conferences and seminars at national level. So with this, I welcome Ravi ji. Ravi ji, over to you. You can share your tech. Yeah.
Thank you so much, Jatin, for inviting me and giving me this privilege to share my insights about the understanding about this deriving value. So deriving value from IPR insights for startups and academicians. So today's topic, there are a lot of nuances involved into today's talk, and a conglomeration of various issues have been tried to be covered under this 1 hour talk that I'm going to give. In the later part, I will try to find out if there are any question answers that can be addressed. The main intent of doing this webinar is to resolve or to prevent any disputes for any prospective collaborative research. Now, basically what happens whenever there is a collaboration happening, it is supposed to be done through a agreement already being signed between two entities. But recently we have realized that there were several instances where collaborative research has been ongoing without jotting down these key points through an agreement. So this misunderstanding among two parties has led to the dispute situation. And at a later stage, when things are not jotted down in writing, it is very difficult to find out whose expectation was what and what were the deliverables expected from one party. And here comes the case wherein out of this collaboration, IPR has arisen. Now IPR has been developed, collaborative research partially has been done, the ownership has not been decided. Now the end goal or the logical conclusion of this entire collaboration has been withheld just because an agreement is missing in this entire conversation. So I'll be sharing few success stories which has initiated as an academic project and later on resulted into some products from IIT Kanpur. We call them as success stories. Why? Because these were the projects onto which some MTech or PhD students have earlier worked along with their faculty members. Later on, when we got an opportunity to reach out to industry partners and convince them that yes, this is what we have, by collaborating with you, not only calling it as a technology transfer, but our intent is to collaborate it with you and take it from the current threshold of, say, prototype and transition into a product. That was the main objective, how we proceeded ahead and reached out to industry partners, and we received success in terms of as the final outcome of all these collaborations. I have two success stories right now. One is the recent gene therapy technology transfer to Laurus Labs Limited. This is a different set of IPR portfolio, different set of applications. I have another technology transfer, which is again ophthalmic based application, gene therapy technology, which is again developed by Professor J.G. Rao in the same case. Why I have shared this technology transfer in today's deriving IP value. So kindly bear with me. The main rationale behind sharing this success story is very important. So Professor J.G. Rao has initiated this work in the year 2003 or probably 2004. And it was a research work which was initiated during his doctoral studies. Later on, it transitioned and continued the same during postdoctoral or during the research work as a researcher. And it took almost 2 decades for the technology to reach out at such a threshold where an industry can show some interest. Why I'm sharing this? Because most of the participants are big grantees. They are eventually coming from agri-tech innovations or biology or life sciences or medtech innovations. It seldom happens that we initiate the research and the research results into a product within a time span of 6 months. At least in the domain of life sciences, this seldom happens. So here is the case where even for getting some interest from the industry, it took almost 20 years. And even despite spending this much amount of time, the industry is going to take another 6 years of time. So now we have gene therapy technology, which has been developed. Now it is not in at such a stage which can be administered directly to a human being. Clinical trials and different phases of clinical trials and the development of product from the current form to a viable form, all this would involve involvement of the industry partner. And for doing that, we need some resources. When we say we, the academic institution plus the industry partner. And it is not possible for an academic institution to gather all those resources just by these public fundings. But this became possible through a collaboration. In a sense, it looks like a technology transfer. To a different perspective, it looks like a collaboration. One party is offering a technology at a certain threshold. Other party is stating that, yes, we own this technology on maybe exclusive or non-exclusive basis. We agree on spending or funding the project for so and so years with so and so infrastructural support. Scientific expertise, manpower expertise shall also be provided. Upon reaching near to product stage, we will utilize other resources of ours and will certainly try to exploit the market using this technology as and when it reaches the product stage. So this is one of the examples of making a product or developing a product through collaboration. This is another example of a collaboration. Again, it falls under the technology transfer category. We have a watch which is made for visually impaired. Again, this technology has several users because India is the country where maximum number of visually impaired people live. A company which is into mobile accessories, development, manufacturing, white labeling, we reached out to them. We said we have a technology which somehow can correlate to your existing products. We are agreeing on developing this technology. Would you agree on utilizing your resources and spending your time in developing this as a product? And it's not a mere technology transfer wherein we wash our hands after the agreement signing. A hand-holding support will be provided from our side. The resources that are required for the validation will be available at your disposal. And this is another collaboration which has resulted into a product development. Another success story, we reached out to one of our incubatee in December 2021. We reached out to several industry partners. It was a soil testing device, one of its own kind portable soil testing device, which can detect the macronutrients, say in 90 seconds, that too through a mobile application. And conventionally comparing it with the lab results used to take days. Now we have a technology or a product which is providing a solution or results in 90 seconds. The number of uses, the limit to it is around 1 lakh tests. So even for human being doing lab tests on recurring basis, this is not possible in such a short span of time what this technology can do. We reached out to our industry partner, Agronex. We somehow convinced them that yes, this technology is at a certain threshold. The gold results have been tested. Now we need more and more soil sample. We need a marketing expert and industry partner who can develop this technology further. And our labs are available for such collaboration in developing this technology from the current stage to a product. All those nuances were covered. Based on those nuances, a proper agreement was jotted down. Now, this is a key important point that needs to be noted, that why do we sign such an agreement where product development is the logical fate? A company can simply take away the technology on as is where is basis without writing anything about the milestone. Similarly, academic institution can also do the same without jotting down the milestones required or the deliverables required from the other party. But both things are interrelated. One party is benefiting through this collaboration by developing this product and selling it into the market, making revenues and profits. Other party is making revenues, or you can say generating revenues through the royalty received from the licensee. It is one of the collaboration that I foresee. Similar could be the case with startups, wherein two startups are collaborating together. One is saying, I have the objective of developing a machine. I'm a big awardee. I've been awarded a big EIG grant. Now the logical conclusion for me is to develop a technology into a product. But for that, I need some components, where the components are required from XYZ expertise. I do not have the expertise. I would be requiring your help for that as well. So one party says, yes, we can provide you those specifications in so and so time. But what will happen to the foreground IPR? So this is the case that often arises. For example, two entities are collaborating together. One entity is paying, another entity is deliverable, giving the deliverables. Based on this pay, or what you can say pay for work for hire, will there be a scenario when when the patent application arises or the patent application gets filed? Are those inventors who have worked in lieu of the compensation or in lieu of the consideration, are they supposed to get the inventorship status? Although the answer varies from case to case, but the thumb rule for this is, when I'm performing my expertise in lieu of some compensation, I'm not supposed to get inventorship status in a patent application. On the other hand, if I'm going beyond my expertise and developing the invention or helping the team in developing the invention in such a way that it qualifies the inventive and novelty both criteria and it has industrial applicability, then I'm supposed to get as an inventorship status as well. So it is a very thin line criteria, but basically we need to understand whether we have a written understanding between both the parties or not. My understanding while working on an invention or a patent was, while developing this invention, I was expecting that on the D-Day when this patent application will be filed, my collaborator XYZ startup would certainly give me a status of inventor, or maybe give me the status of co-applicant because I have given my effort in developing this invention from scratch. Now, both the entities have some expectations where the first entity is expecting when I'm already paying for the work, it is falling under the category of work for hire. So am I supposed to further depute or designate the status of inventorship or applicant status. Because the moment one becomes an applicant of a patent application, co-ownership starts. And when the co-ownership starts, the right to license, the right to sub-license, and even the partial ownership towards the revenues are also decided. The fate of all these things are being decided who the applicant is. Just giving you an example, the academic institution IIT Kanpur by default is the applicant for all patent applications filed by the faculty members, student and staff. The moment it comes to that stage where the licenses are supposed to be given to industry partner, the decision to license or not to license lies with the applicant, not with the inventors. And what makes it easy, or what creates these situations in such a feasible manner, because at the end of disclosure form, or by default the policy, IPR policy of the institute, which states that the inventors who are employed within the organization getting paid in lieu of the work, the IPR, intellectual property rights generated by them, shall be owned by the institute only. Again, there are several nuances to it where we come across several cases from private academic institutions where this question is often asked to us. Sir, I am a faculty member at so and so private engineering college. I have developed an invention after my office hours. Will I get the ownership of this patent because I have not used the resources of my engineering college? Or you can say another case study where another example. Me and one of my friends who also happens to be a founder of a startup, we both have our startup companies. We are working collaboratively, and we work for time being. Now that collaboration is over, but after gaining some experience through that collaboration, I think I have a better idea than the conventional technology what my friend was developing. So can I file an independent patent application without giving an applicant status to my friend who was earlier collaborating with me? So it is not possible when you have collaborated together and you have gained information about the idea, and tomorrow you say that I have not gained this idea through that collaboration, but it is an enhancement or the addendum of the existing technical work which was done by so and so collaborator. Now the answer to this is, or the solution to all these three problems is signing an agreement in the first go. The moment someone feels that a collaboration is possible through adjoining or collaborating together, it is advisable to discuss all these things in writing over email. When you mention that so and so work needs to be done, what will be the fate of the background IPR that I am owning? What will be the fate of the foreground IPR that will arise through this collaboration? And when we'll be filing a patent application, when we will be protecting our ideas through this collaboration. For example, we have developed an invention which is at a nascent scale, and we expect that further research is expected, further experimental results and data is expected in the next 12 months. And we do not have complete results. In those cases, it is advisable to go ahead and file a provisional patent application. But this collaboration is ending in a 3-month time because already this has been ongoing for past 9 months. One partner is saying, I cannot spend another 12 months. Why should I file a provisional patent application for this collaborative collaboration? I only have 3 months remaining. I'm quitting this collaboration in next 3 months. So my advice is to file a complete patent application. So situations like these demand written agreements where the fate of IPR has already been decided. In those cases where the technology developed is at a nascent TRL, say TRL 1, 2, or 3, in those cases, it is advisable to go ahead and file a provisional patent application. And also, some exit options should be given. What if the collaborator insists on exiting or wants to terminate the agreement? So what will be the fate of this IPR? If one party is terminating the agreement, in that case, the invention should not suffer. So one party may still get the applicant status or the co-applicant status, but the right to commercialize the technology will be with the first party only, or with the party who is continuing with the development of the technology. So there are several variations or several permutation combinations to such arrangements. But if these arrangements are in writing, it becomes very easy to avoid such disputes. Often such questions are asked, when is the right time to protect my idea? When should I file a patent? Patent should be filed at the ideation phase only. It is a misconception or a myth among the research community that patent can only be filed as and when a product or a prototype is developed. That is not the case. Another question comes, I have an objective X, my competitor is also having the objective X. So how to stay ahead of my competition? I'm developing a technology which I'm planning to launch it as a product in next 12 months of time. My competitor is also planning to do the same. I somehow suspect that my experimental works that I'm doing, if it gets leaked, all my idea will be utilized by my partner and will be my competitor and will be filed as a patent application. It is advisable in such cases to file a provisional patent, not only a provisional, but a portfolio of IPRs. The more you develop, more patents or IPRs should be filed in such cases. For example, you have developed a product or maybe a process where the unity of invention cannot be defined. For example, I have submitted a disclosure form, or what I was assuming to be a single patent. Later on, at a later stage, after discussing with the patent attorney, it came out to be a set of patents where the unity of inventions cannot be decided. In such cases, a couple of patents should be filed. Expedited publication, expedited examination, these kind of modalities should be used for the filing of such patent applications. Gone are the days when the patent application used to take some 2 years, 3 years, or 4 years of time. Now patent applications are getting granted in less than 7 months, 8 months, 12 months of time, just by using simple forms like Form 9, which converts your 18-month period into 1 month, and expedited publication, which converts your 48-month to 30-month to 1 month after the date of publication of the patent. So out of the 48 months, you are overall, in a sense, right sizing 41 months by paying some extra fees. And even for this extra fees, there are waivers for the startup entities. So government has already subsidized the fee. So there is a 80% official filing fee waiver for startups. And also the queue for examination of patent application by startup is generally happens in a different queue only. So your patent application will have priority in comparison to a patent application which is coming from a larger entity or from maybe from a limited company. So these are the nuances which should be thought upon. Always keeping an agreement for collaboration, filing provisional patent application, developing a portfolio of IPRs, filing trademarks for word marks, logos, device marks. These are the minute strategies which will prevent any dispute, which will prevent or will give you an edge over the competitor. Now, another question comes at what stage the patent application should be filed. For example, if I have filed a patent application today, I'm bound to submit the complete patent application within a period of 12 months. And here is the case where the collaboration is already ending within a period of 2 years. So 12 months is the time that took in developing the invention or conceptualizing the invention. Now, when the 12 months have come, it is at a provisional stage. It is taking more than 12 months of time. What should one should do? There are options for applicants. For example, if one has filed a provisional patent application on 1st of January and someone thinks that 12-month period is not sufficient for a life science based technology or agri-tech based technology to convert into a complete patent application, the patent office provides an option of post-dating your application. So the provisional patent application which was filed on 1st of January, the same priority can be post-dated by another 6 months. So the priority would shift from 1st of January to 1st of July, and the deadline to file a complete patent application, there will be another grace period of 12 months. This is one of the strategies. Several life science based companies, MNC companies are doing another strategy wherein cognate patents are being filed. For example, I'm developing some drug or some molecular development is ongoing. Now this development, just in order to prevent this invention, I have filed a provisional patent application. I was expecting results in 12 months, but that could not be materialized. The deadline is nearby. What am I supposed to do? In that case, what I am going to do is to abandon the provisional patent application. I will abandon the first provisional patent application. Why? Because the advantage with provisional is it never gets published. So the idea that you have tried to secure by filing provisional patent application, no one will ever get to know what you have filed in provisional patent application. So you can subsequently file another provisional patent application, or you may keep on filing until you feel that the experiments are sufficient enough to be filed as a complete patent application. So this is one of the advantages with provisional, that you can not only post date by another from 12 months to 18 months, but also decide not to publish or to abandon the previous patent application by going ahead with the process of cognate patent application filing. Another question comes for collaborative research, how to proceed ahead with a collaboration. Now I have developed an IP, or my research has already reached at a certain threshold. What am I supposed to do? Now, startup company X, startup company Y, they both have collaborated at a stage where the research was at a very nascent level. Both the entities, through verbal agreements, have committed to each other that as and when you provide me the components, I will reach the product phase. As and when the revenue comes out, rather than giving you monetary compensation at the immediate effect, I will give you some X percentage of the revenue as and when I reach out to the product phase. But what happens in between? There is a dispute that arises. One of the companies Y states that the compensation needs to be paid because the components that I am sourcing are being sourced from market and they are expensive in nature. I cannot wait for this technology to become a product and reach the revenue or the post-revenue stage. Now, the product which was supposed to be developed in XYZ time through some government grants like BIG has been withheld. The main reason behind that is both the entities have forgotten to sign an agreement together and decide the deliverables for each of the parties. And here comes this vicious circle that you see in front of your screen, although this is more relevant for technology transfer process flow. But in this stage as well, whenever you would like to collaborate with any entity and you feel you are the standalone entity, you have done your research, you have filed your intellectual properties, you have filed patents. Now you think that a collaboration is required and a confidential disclosure is required. In that case, do not proceed ahead until unless you file an NDA with the party. Several instances it has happened that often entities come and convince you and say that, yes, I'm already into the market. NDA is just a formality. Let's disclose it. It hardly matters. These things are superficial in nature. There is no relevance of having an NDA. But to my experience, what I have observed is many times it may not create the dispute, but we do not know which are the times which will create dispute and which are not. So NDA signing is utmost important. Even templates are available at various websites for such signings. You do not need very fancy NDAs. Simple NDA templates can be utilized, where in simple layman terms, all these things can be written. In case of professional help is required, which we solicit and we advise all the startups to go ahead and certainly utilize those professionals who have the expertise in drafting and vetting such NDAs, which are customized for each and every or domain of work for collaboration. For example, an NDA for life sciences having similar deliverables would completely be different than an NDA for engineering domain. So today I'm saying I have a confidential idea which I do not want to disclose. Now, tomorrow, my collaborator, just before signing the NDA, has disclosed this on the website or in some scientific community. Now, I do not have the option to protect my invention just because the patent application has already been filed by several applicants or utilized or is already available in the public domain. So, would this breach of trust or would this damage that has been done? There is no way that the monetary compensation would suffice or would resolve this breach of trust which has been done. To make a remedy, to frame the remedy of such kind of disputes, an NDA is solicited in such cases. Similar is the case as and when we are proceeding ahead for a collaborative research, an agreement is always advisable. One must sign an agreement as and when you are stating some deliverables, expecting some deliverables. Please talk about foreground IP, background IP, what will be the monetary compensation, what will be the percentage of royalties that will be involved. All these conglomerated different key points make a good agreement, and eventually at the end, when both the parties feel that this agreement has frustrated just because we have not reached the logical conclusion, we still have the right to give the notice of 30 days in advance and terminate the agreement. I would skip this establish your brand entity because I'll be covering this at a later stage as well. This was one of the aspects of building your brand or establishing your brand. I will be covering this at a later stage. Now, for startups who are already deprived of resources or do not have the bandwidth to gather resources, or the crunch of capital is ongoing. In such cases, if disputes arise, it is not possible for the continuation of product development. Because in general, whenever we observe, there are hardly 2 or 3 employees involved in the product development. And it is not possible to depute the financial resources for the prevention of such disputes. So at that moment of time, if you have these key conversations in writing or over email, Mr. X has committed Mr. Y over email. Now, after this conversation, there was subsequent conversation where both the parties decided to discuss all this in a verbal manner, not having any records of this conversation. So what will happen to this collaboration? What will happen to the commitments or the deliverables that are expected? Signing NDAs before disclosure is another key component. Milestone capturing through agreement. Rather, fourth point is arbitration mediation is a way to avoid dispute, but one should think from that perspective that we should not avoid signing NDAs and agreement, which would lead us to this fourth remedy, arbitration mediation, which itself sounds like a remedy, but itself is a time-taking process. Different prospects of IPR. This I would not go much in detail because in a sense this revolves around the intellectual that has been developed through this collaboration. I will try to cover this up ASAP because already we have progressive entrepreneurs who are aware about these nuances. So we have different IPR prospects like patents, design, trademark, trade secret, copyright. Now, here is the case out of this collaboration. One party commits that whenever this product gets developed, I'll be using your logo on my products as well. Because my components that I'm developing are eventually being used by the product that you are developing. So it is a co-branding situation. Now, this entire conversation was done in a verbal manner. There was no record of this conversation. As and when the product gets developed, one party starts using the trademark of another party. Now the agreement has already exhausted, or the agreement is not surviving anymore. One party sends a notice to another party for not using the trademark. So had it been a case where such type of things have been jotted down, it would have been easier for each party to utilize its commercial benefits through these IPRs. One of the key components, or often this question is asked, Section 3 of the Indian Patent Act often suggests that the process of doing agriculture is not patentable. Yes, I do agree. Or the process of doing medication is again not patentable. So, sir, how do I file a patent application? So we are not expecting a process of agriculture or a process of doing some medication or the process of treatment or therapy. What we are suggesting is whenever you have a product or a process which has application in medtech, biotech, agriculture, or medical sciences, if it falls under the category of product and process, you must file a patent application. Now, those incubators who are already into agriculture or agri-tech domain, whenever there is a pathogenic infection and one farmer is using insecticides against the same, I don't think it will give him better results. And vice versa, when there is an insect spread in the field and another person is using some metabolite which will result in decreasing the pathogenic spread. So vice versa, each application should be relevant. What I have in front of my screen is a biodegradable carbonide metabolite nanoparticle, which has been explicitly developed to prevent such type of pathogenic spread in the paddy fields. Now, this process is kind of novel. It may look obvious to a few people, but it is not the case. Now, subsequently, there is another question from the startup community. Sir, shall I disclose everything in the disclosure form? Shall I keep something as confidential? Now, Startup X has done 3 years of research, which has led to a specific 10-step process. Now, this process has a very key step number 3, where the temperature, which is wherein the nanoparticles are subjected, are 94.6 degrees Celsius. As and when the patent application is being drafted, it is drafted in such a manner where the range of temperature is giving from 85 degrees Celsius to 115 degrees Celsius. I have 2 advantages in drafting my claim in such a manner. The first thing is I'm not disclosing the confidential or the black box of the invention that I have developed or the step 3 of the process. The second advantage that I have is I have a broader coverage. Tomorrow someone comes as a competitor to me, brings another process innovation which has a temperature utilization at 89.5 degrees Celsius, and I already have a patent being granted with a temperature range of 85 to 150 degrees Celsius. These are the 2 advantages that I have. But these things, these nuances, they require anticipated or a preemptive strategy that needs to be devised at the time of filing IPRs. And these comes with experience, and experience comes with volume. So do take help of those professionals who already have expertise in drafting NDAs, signing agreements, drafting agreements, filing IPRs. With these key nuances and strategies for collaboration, for filing IPR, for developing product, one will become ensured whether what kind of applicant status I'm going to give, what kind of inventorship I'm going to give, what royalties or revenue sharing will be given to each party, and what will be the exit door policy in case one party is not satisfied during this collaboration. I think I have already covered a few nuances. Jatin, if the participants would like to ask any question, I'm open for that.
So Raviji, we already have some questions in the Q&A box. So I will read one of them one by one, and you can answer them. So first question is from Dr. Padmakar. Please let me know if there is any ACT which allows the government department can buy the patented product without calling for tender.
Okay. Somehow multiple things have been asked into this. I will try to simplify. So, Dr. Padmanabhan, am I right?
Padmakar.
Dr. Padmakar. Okay, I think he for PCT is just another tool of expanding the deadline for filing patent application in foreign jurisdictions. Number one. Generally, conventional applications can only be filed within a time period of 12 months. If someone wants to expand this window of 12 months to 31 months, he can simply file a PCT application. That is what Patent Cooperation Treaty stands for. As a state to TRIPS agreement, since India is a signatory to TRIPS, so that's how these treaties are applicable to us as well. Now, the second thing that he has asked, whether the government has the right to take away the IP without giving any notice to the applicant or to the owner or not. This is my understanding as per the question that you have just read it out. Now, there is one clause, one section in the Indian Patent Act 1970, which states that compulsory licensing, I'm going to simplify this section, compulsory licensing. For example, I have the patent application for a drug which has some public demand. For this public demand, I am unable to supply the good. When I'm unable to meet the public requirements or the demands of the public, the government has the right to take away the IPR and license it to any other third party who has the capability on a reasonable price. This is what compulsory licensing is. Although technically I can go much in detail, but these are the terms as per the question that Dr. Padmakar has asked. So PCT, more than 12 months, you can file a patent. Compulsory licensing allows government or the IP India office or the Controller General to take away the IP and give it to those who have the bandwidth to meet the public demands.
Thank you, Raviji. The second question is from Tulsi. Approximate what charges should be of patent attorney and how much we should give to him for patent filing and process.
Okay, so for patent application filing, one needs to understand that there are two components to it. One is the fixed component, that is official filing fee, which has been subsidized at 80% discount for startups and education institutes is already there. So if someone is simply going for a Form 1, without expediting the patent application, it is going to cost 1,600 rupees. But the moment someone files Form 9 and Form 18A, which expedites the publication and expedites the examination, it is going to cost somewhere around 12,000 for the expedited examination. Overall, it is the official filing fee would be 15,000 rupees. The second component for this patent filing would be the professional charges of the attorneys. So one can simply understand that attorney at the time of filing a patent application somehow charges between 25 to 35,000 rupees. And there are 3 steps to patent application. One is the filing stage. Second is the prosecution or the examination or the hearing stage. And third is the annuity payments. At the time of patent application filing, the professional charges would be 25 to 35. At step number 2, examination and hearing, again, the hearing and examination response would incur a professional charge of 20 to 30,000 per examination or per hearing. The third is the annuity payments, where the government fee for maintaining the patent after grant is 800 rupees from the 3rd year onwards up to 5th year. From 6th year onwards, it is 1600. Subsequently, keeps on doubling. So these are the 3 steps, 3 charges. The gross charges for filing a patent, grant, and maintenance till 20 years comes out over the period of time to be INR 1.5 lakh rupees. So these are professional charges which may vary from attorney to attorney, but in a sense, this is the general trend what we have been observing recently.
So, the next question is from Hindol Bhattacharya. Is litigation over IPR/NDA/agreement worth the hassle and monetary capacity for individual inventor or startup?
Not at all.
Okay.
Even I'm also a lawyer by my educational qualification, and the commercial courts in the country are doing exceptionally good as and when it comes to disputes like this. But it is always advisable to go ahead and settle these disputes out of court, and prevention is always better than cure. So have your NDAs, have your agreements. We never know what will happen in the litigation suit. One should not just withhold their rights by withdrawing their patent application or the rights that they are supposed to get. But my experience in comparison to litigation, I think keeping a proper paperwork for your invention is much better than going ahead that way.
So the second question is, next question is, if a student from IIT Kanpur filed a patent and later want to go for a startup for that, is there any license transfer fee for that?
So as per the recent student entrepreneurship policy, students coming through this IPR, this SEP policy, which is operationalized by Dean of Academic Affairs, where the forms and applications are available at DOA. There will not be any license fee for SCP applicants for the students of IIT Kanpur. But earlier, this was not the case. This SCP has been floated recently only. So the answer is there is no license fee for such licenses.
So the next question is, does filing the patent and publication in general start protecting my invention? I think the question is, I think it's not spelled correctly.
Yeah, actually, if you have already published your research or an invention prior to filing of your patent application, then you won't be able to get the patent application because your own publication becomes anticipated. You publish your invention prior to the date of filing of your patent application. So when the invention gets anticipated, it doesn't remain an invention. So for filing a patent, an invention needs to be qualified. So patent first, publish later. This should be the strategy for protecting the invention.
If an IIT student filed a patent and for further going it require an clinical validation in hospitals, will IIT help in that if the product is of invasive type?
Okay. So for such validations and doing experiments which involves human subjects, first of all, you need to get ethical approvals. This is generally done by committees like human ethics committees. These committees are already existing in the institute, so you may approach them. So far, this help is considered. Jatin, you may answer this student that bio-niching grant is already available and you are more than willing to help the student in developing or validating. So this answer can be given by you as well. So there are grants available for students graduating.
So we have around 35 grants open at SIC IIT Kanpur. So if you want to develop your product or if you want to commercialize your product, we have all type of grant and support that we can provide. We have good connections in the hospitals, local hospital and other hospitals also within India, outside India, which can help you in the clinical validation. We have tie-ups with some CROs also, contract research organization like Novartis, IQVIA, which can help you in developing the clinical trial studies. So yeah, if you have any queries, you can reach out to me on my mail ID and on my phone number. That's the last question that I have for now is, sir, I have an idea, but I don't know any coding language to develop application. What should I do? So maybe I can take it up. You can come to us. We will help you in getting a team. We will get you connected with some of the computer science students or interns. We will help you in getting it, and we will try to help you in some or the other ways. So I have one candidate who, I have one more question. Sir, I have an idea and I have made a PPT and prototype of application, but okay, this is same, but I don't know the programming language to develop the application. Can I take patents of an idea uh, from patent and PPT? I can't understand anything out of it, Ashutosh. Maybe you can raise your hand and we can allow you to speak. So we have one candidate who has raised his hand, is Abhinav Mishra, and I'm allowing him the room. Abhinav, can you hear me?
Hello.
Yeah, Abhinav, Mr.
Yeah, I'm
Ravi.
audible.
Yeah, you are audible. Ravi sir is here. You can ask your question.
Okay, thank you. Hi, Ravi sir.
Hello.
Thank you very much for the insightful talk and opening our minds. So one question here is, in case the government institution developed the technology and any private company did a technology transfer with the government institution, and who has the rights to take the patents?
Okay. Who is
Whether the
take the patents?
whether the government institution who developed the technology and did the technology transfer to the private institution, he has the right to do the take the patent, or the private institution has to take the patent, or if there is some extra addition done by the private player on the top of that technology, they have to take the patent.
So, there are multiple answers to this question that you have asked. First of all, it is going to be dependent on what was the understanding between the applicant and the licensee who has taken the license. Number one, what were the terms and conditions that were written in the agreement or the licensing agreement? If it was given for a certain time period, say 5 years, then the license shall be held by the licensee who has paid some consideration against the license to the licensor. Number one. Second thing, in case if you are asking as and when, even if the licensee is unable to meet the public demands, who will own the patent? So the licensee will continue to hold the license, but partial license or the non-exclusive license shall be given to another entity who has the capacity or the bandwidth to do the mass manufacturing. So this entire ball game is all about doing mass manufacturing. If one is keeping the patent application or the rights with them and promoting monopoly by not meeting the public demands, then this Patent Act 1970 compulsory licensing comes into the picture. And in that case, the government has the right to take away based on reasonable pricing and give it to someone who has the bandwidth of manufacturing. I hope I did answer your queries.
Yeah, thank you.
Okay, I'm letting in Dr. Padmakar. Dr. Padmakar, can you hear me?
Can you hear me now?
Yeah, I can hear.
Dr. Padmakar.
Yeah. Thank you very much, Ravi. See, I have already got a granted patent. It is related to agriculture. I'm trying my level best for last almost 15 years to crack the project, crack the customer. Fortunately for me, MPKV, that is Mahatma Phule Krishi Vidyapith, have got the funding to buy. Now the question is, will they be able to buy directly from me the equipment what they want? the specifications what they have is exactly matching my patent, or
Okay.
they will have to publish the tender, get the tenders, and so on and so forth.
Okay. So they cannot supply such type of products with such specifications wherein you already have the, in case if you are feeling that they are infringing upon the specification wherein you already have the granted patent, you may
Yeah.
simply send a notice to the entity doing the infringement. This is one of the points. The second strategy would be to become a customer in disguise and collect some evidences against them,
Okay.
and uh, collect some invoices, receipts, and the delivery details, reports of the product being provided by them. Keep all these evidences with them. Then you can reach out to commercial court, submit a plaint. Based on that plaint, you may request for an injunction over the entity doing the infringement. The injunction will enable a status quo for that entity. They will not be able to do the manufacturing further, or the supply of the good wherein you already hold the patent. The third thing that will continue after this injunction is to calculate the damages that have been done by the infringing party. So either they are supposed to pay the damages in terms of liquidity, or in terms of monetary damages that they need to compensate you, number one, or some prosecution action needs to be done against them. The third thing what can happen is to have an out of court settlement where both the parties agree on a consensus in terms of consideration against the licensing of the technology. So both parties agree. With mutual agreement, you can simply license the technology to that entity. So all these options can be explored. Many times we came across a situation where even by mere sending a notice, the infringing party has agreed on taking the license. So you'll have to figure out in which category you are falling right now. If it is a matter of some tender alone, where time is we are running short of time, or a 60-day or 45 days period of time is there, you may immediately take help from some legal advisor or an advocate who can file the plaint and who can submit this plaint to the court, or you may initially send an advance notice asking the infringing party to withdraw from the from applying from this tender. So all these remedies can be utilized.
Okay. Okay. Thank you very much.
So I'm taking the last applicant who wants to ask a question. Indol Bhattachar, can you hear me? Hello.
Am I audible?
Yes, you are audible. Yeah. You can ask your question.
Yes. Thank you, Ravi sir and Jatin sir. I want to get a clarification on the second question that I had asked. So when I meant by publication in the journal, I meant the publication in the journal of the Indian Patent Office. So first, the patent application is, I believe, published in the journal, and then the rest of the steps go on. So my question was that whether that publication in the journal itself gives a protection.
Okay, are you trying to say that this journal provides you some protection over your competitors? Is that what you are asking?
Yes, yes.
So you'll have to understand that the objective is different for a journal, and the objective for a patent application is completely different. A research paper or a journal is they can even accept discoveries, while a patent application cannot accept discoveries. Journals are basically academic tools, while patents are not. Patents are supposed to generate revenues. If there are no prospective revenues expected from an invention, there is no point in filing a patent application. So both objectives are completely different. I do not understand in what context you are referring that protection can be provided just by mere publication or publicizing the research work in a journal.
Sorry, sir. Sorry, sir. I meant when I meant journal, I didn't mean the scientific journals. I meant the journal of the patent office.
Oh, for journal of the patent office, you need to file a patent application first.
Yes, yes. But when it's published in that journal, is the
Ah.
protection begins from that stage?
Protection begins from that.
Okay.
Priority will be from the date of filing only,
Okay.
but the protection will be from the publication date. The calculation of damage payments and the infringement will be calculated from the day of publication. When the public gets to know that the so and so invention has been done by so and so through the journal.
Okay. Thank you. Thank you for the clarification.
Thank you, Raviji. We are done with the question and answer. So thank you, Raviji, for such an insightful session. I think I and the attendees have learned something new today in the field of IPR. Thank you for your time. Thank you to the entire IPR team. So if you have attendees, if you have any further questions, my mail ID and Ravi sir mail ID is in the chat box. You can. Yep. So thank you. I'm closing the webinar.